Coleman is going to speak to us first. He's with Perkins, Coie in Menlo Park, and he is going to speak to us about one of those words that always makes me nervous and uncomfortable, outsourcing, because you can outsource your moderator right now, and I wouldn't have anything to do today. And I asked each of our panelists before they started why they became a lawyer. I always find that is helpful to younger lawyers to remember that we all have different tales for how we came. And he told me he entered this profession in IP because his ex faxed his resume to somebody saying he'd make a good patent agent. The only problem was Brian didn't know he was looking for a new job. And then our next panelist will be Robert McFarlane, who's with Townsend and crew, and he's going to talk about privilege issues in foreign patent prosecution and how that relates to our practice. And I asked him if he could top Brian's explanation, and Robert said not in public. So at the break, I encourage all of our young attorneys and aspiring attorneys to go ask Robert personally to elaborate on why he became a lawyer. But he did tell me it had something to do with following a punk rock band. So I'm sure it's a good story. And finally, John Steele is with Fish and Richardson. He's a lecturer at 3 different law schools in the area of ethics. And he is going to talk to us about the ethical and geographic limitations of licensing practices and the unauthorized practice of law. And he became a lawyer because he had no choice. There are 18 lawyers in his family descended from his grandpa, and so he had to hold his own at family dinners by joining their ranks to argue. So we're going to, and I've asked each panelist to speak for, about 10 minutes or so, and then we'll open it up for some questions from all of you. So, Brian?
So, my name is Brian Coleman. I'm with the law firm of Perkins, Coie, where I'm a patent attorney and a partner there. And I'm a little blind today. I broke my glasses just as I was getting out of my car, so I won't be able to see you yawn, but I also won't be able to really catch you. So if you want to interrupt me or something, wave. It's a true story. I was working as an engineer and came home from a trip, and there was a voice message saved for me from a guy, Paul Hickman. I don't know if any of you guys know him. He's a patent attorney in the Valley here, and he said, "Hey, I liked your resume. I'd love to interview you." I didn't know I was looking for a job. I figured for the sake of marital harmony I should go see what it was all about, and I went and met with Paul, and he gave me a 1-hole punch and a 2-hole punch, and he said, "This is the prior art and this is the invention," and he made me write about it, and I fell in love with it, which is kind of a strange thing to say, but I love writing patents, and so here I am today. I'm going to talk a little bit about something that might actually jeopardize what I love doing so much, which is outsourcing of IP legal services. Let me start my watch so I don't go too long. It's something that clients have come to me the past 5-6 years and have suggested that I do, maybe for cost reasons or efficiency reasons. It's not something I can say I've had good luck with. I continue to have people suggest that we try it and keep looking for ways to do it. So I don't think the issues that are problematic with it. So you probably all know what outsourcing is. You've heard a lot of buzz about it. It's really taking services that are traditionally done in-house, whether they're like IT or customer services or patent drafting, and moving them to someplace outside of the inside structure. In this case, specifically, we're talking about foreign outsourcing. The motivations for doing it vary. One of them is just convenience. Perhaps you don't have the bandwidth available to get the project done that the client needs to have done. Cost savings is the big one you hear everybody talk about, although I haven't seen it personally. But the idea that different economies can support making cost savings that result in profits for the law firm, and then some of them can get passed on to the clients. And then the other one is focus. I think this matters more to in-house counsel if they're outsourcing their work. They probably don't want to maintain the expertise inside. It's not hypothetical, legal outsourcing. If you go search right now on the internet like I did, you'll find at least 50 agencies that are offering services such like prior art searching and patent application drafting and litigation support, and it's happening all over the world. It's happening a lot in India and Russia, but you'll see it happening in other places too. A lot of issues come up when you send work outside of your office. A client engages you You're subject to the rules of the bar that you're in, and these rules are going to apply pretty much no matter what, whether or not you outsource the work. People have been outsourcing projects for a long time, but it's a new thing doing it to foreign jurisdictions. The 5 issues that seem to come up in the opinions that I've looked on this, and there's kind of a scarcity of opinions right now, but the 5 that come up are maintaining the client's confidences and secrets, issues dealing with conflicts, the unauthorized practice of law and competent representation, billing and fee sharing, and gaining client consent. Addressing the client's confidences and secrets first. Something that the lawyer has to be aware of is that the rules are very different depending on the jurisdiction that you're in. The one that I saw coming up a few times, that there's a lot of jurisdictions don't have the typical privilege rules that we think of here, that communications with your clients are not necessarily privileged. So it's something you have to address when you're going and looking for outsourced services. You need to be aware of the rules that the foreign jurisdiction have. Kind of some ways that I thought about to address this is to really restrict access to the confidences and secrets. Be aware of how your outsourcing provider is handling the data, and make sure you have control over who actually uses it. Kind of keep it a need-to-know basis. Probably you want to take care of some of these problems. Since the rules are different, you want to have contractual arrangements that actually address how the information will be handled, and also provide remedies if there's a breach. You would also probably be wise to have periodic reminders to your outsourcing providers, and just let them know what the rules are that they should be following, and do a constant review of how they're disseminating the data. And then we're going to talk a little bit about when you need to let the client know, but it certainly looks like it's a rule now that if you're disclosing confidences and secrets to foreign lawyers and non-lawyers, you need to let the client be aware of what you're doing. Conflicts. Again, this is a situation where jurisdictions have different rules as to conflicts, and in the U.S., the U.S. attorney really needs to maintain records of prior and current engagements, and then have a system for checking proposed engagements. So it's probably wise to impose these restrictions onto the foreign provider of the outsourced services. So this one I thought was interesting. It came up in an opinion that happened in the New York State Bar. The concern was over whether or not there was an issue of assisting a person who is not a member of the bar in performance of activity that constitutes the unauthorized practice of law. And the way they dealt with this really was that you need to perform rigorous supervision of the foreign associates, and it was pretty strict in the test, or the rules they laid out, that you actually needed to interview the people that were going to be working on the cases, whether by telephone or in person, look into their references and make sure they were competent to do the work. And then there needed to be an ongoing supervision and then a careful review of the work that was done. Billing and fee sharing, a couple issues come up. There's a duty not to share fees for legal services with non-lawyers, and I guess the concern is if you are outsourcing work to foreign lawyers and non-lawyers, that issue might arise. Same opinion in New York dealt with this by saying it's much like hiring a headhunter, and the fee you're paying, the service, is really for the recruiting, locating of attorneys. It's not for legal services performed. Client consent. From what I saw, it didn't look like there's anything in the rules that really mandates that you let the clients know except in certain situations. So it's kind of a fact-specific situation. I personally, when I've engaged in this, I think it would be unwise to not tell your client you're sending their legal services elsewhere, even if it's just research. But it does appear that lower level things that don't involve strategic decisions, but maybe are generic research issues, there probably is not a requirement to let your clients know. Although I think anytime you're disclosing client confidences or secrets, you need to let the client know. There's also a situation where if your client has an expectation that legal personnel that are employed by the law firm are doing the work, if you change that, or alter it, you need to let the client know so that their expectations are met. So that's all I have. Thank you.
Yeah.
Is it set up on page down?
Yeah, I should just keep it.
I'm Rob McFarlane. I'm with Townsend and Crew in San Francisco, and since Michelle brought this up, I did in fact go to law school because of a punk rock band. I think it was about 1988, the punk band, the Dead Kennedys, got in a huge First Amendment fight, and their lead singer, Jello Biafra, went to tour college campuses talking about First Amendment issues, and I was studying engineering at Stanford at that point and saw him speak at Stanford Law School and thought law school looked pretty interesting, so it is a true story. And so today, I'm not listening to punk rock as much as I used to, so I'm going to talk about the attorney-client privilege in foreign patent prosecution, which is almost as interesting as punk rock. The way I do litigation at Townsend, so the way I'm going to approach the issue is how foreign application of the attorney-client privilege arises in U.S. patent litigation. And the way it arises is when the patentee will assert the patent in U.S. litigation, the accused infringer will invariably ask for the U.S. prosecution history of the patent, and then to some extent the communications with the prosecuting attorney or the prosecuting patent agent in the U.S. And so if it is a patent that has foreign counterparts or related foreign patent applications, almost invariably the accused infringer will also ask for communications with the foreign patent agents or foreign patent attorneys who prosecuted the related foreign patents. And generally, the U.S. courts, under principles of comity, have looked to the privilege laws of the nations in which those foreign patent applications were prosecuted to determine the scope of the privilege in relation to those foreign communications. And so the way I'm going to introduce the topic today in the few minutes we have is just to describe how the attorney-client privilege applies to U.S. prosecution, and then look to how it also, the kind of the unique issues that arise when you look beyond the U.S. borders to see how it applies internationally. And so just as some background, the attorney-client privilege in the U.S. is a testimonial privilege that gives the client the absolute right to refuse to disclose and to prevent others from disclosing his or her confidential communications with their attorneys and then the people who work for their attorneys. Now, it's interesting, historically, the privilege didn't even apply to patent prosecution because U.S. courts didn't view patent prosecution as the practice of law. They viewed it as, akin to business advice or advising in other non-legal matters. But then in 1963, the U.S. Supreme Court declared in its Sperry case that, in fact, patent prosecution by patent attorneys was the practice of law. And so that, I'm sure much to the happiness of patent prosecutors and patent attorneys at that time, opened the door to being treated as attorneys and then being treated, having the attorney-client privilege apply to their confidential communications with their patent clients. And so following that 1963 case, the court still had some hesitance in U.S. cases to apply the attorney-client privilege to patent prosecution. There was a leading case in the Northern District of California in 1970 called the Jack Winter case that took an extremely narrow view of what the patent prosecuting attorney or patent agent did. The court reasoned that there's the statutory duties of disclosure in patent prosecution, and so the prosecuting attorney was nothing more than a conduit of information between the inventor and the USPTO. The court reasoned that there was no discretion in the types of information that they could, or that they were required to provide to the patent office, and so the judge took an extremely narrow view and said, as long as it's just simply technical information, there's no privilege, and really just curtail the privilege application in that setting. And needless to say, that particular case came under pretty wide criticism from other courts who viewed that it was just an artificially narrow reading of what patent attorneys do. Even at that point, there were a plethora of cases that said drafting a patent document is one of the most complex acts that any attorneys do in any field of law, and so it really kind of undermined the dignity of the profession to try to limit what they did to that. to that narrow level. And so the U.S. Court of Claims in 1980 came out with a very influential decision called Canogo that really took the Jack Winter's decision to task, said it was unrealistic, inaccurate, uninformed, and basically extolled the virtues of what and the complexities of what the patent agents and patent attorneys do. And what it did was it used an analogy of an attorney in civil litigation drafting a civil complaint. The client comes to the attorney, passes information on to the attorney determines what's necessary to put in the publicly filed civil complaint, and the act of filing that complaint in a court does not waive the attorney-client privilege as to any consultations that the attorney and client had prior to filing the complaint. And so the court took the same approach to the filing of a patent application, that the inventor goes to the patent attorney, provides him the technical information, the background of the invention, and then the attorney determines what is in fact necessary to file with the patent office. And so the act of filing the patent application does not abridge the underlying confidential communications. And the view of Canogo was adopted by and large by the Federal Circuit in a 2000 case called In Re Spalding Sports Worldwide. It was a narrow decision. The specific issue they were looking at was whether or not an invention disclosure form was subject to the attorney-client privilege. And an invention disclosure form is just typically a short form that inventors fill out and provide to the corporate patent attorneys to give the background information on the invention, the conception and reduction to practice and things of that nature. And so the Supreme Court in that narrow setting did in fact hold that even though it was technical information, it was given to an attorney for the purpose of obtaining legal advice in the effect that the decision of patentability, the scope of the claims, all of those involve legal analysis, so that was within the scope of the attorney-client privilege. And then since the Spalding decision, the district courts have almost universally expanded its ruling beyond the very narrow topic of invention disclosure forms, and have, with one exception out of the Eastern District of Virginia, almost universally used Spalding to apply the attorney-client privilege to the scope of all domestic patent prosecutions. And so that's the basic framework of the U.S. application of the attorney-client privilege. Is the conversations with U.S. attorneys, U.S. patent agents working under the direction of attorneys are in fact within the scope of the attorney-client privilege. There's also a few cases that extend the privilege to registered U.S. patent agents. The reasoning of those cases is that the Congress has set up a statutory framework under which U.S. registered patent agents act in the same footing and in the same shoes as attorneys in proceedings before the USPTO. So to effectuate that statutory framework, they should be treated the same as attorneys for the purpose of the attorney-client privilege. And so it gets a little bit more complicated in applying the privilege to foreign prosecution. And so again, this would come up where you're litigating a U.S. patent, but then that patent has a Japanese counterpart, a European counterpart, whichever countries the patentee may have chosen to prosecute a parallel patent in. And as a matter of international comity, the U.S. courts have determined that the nation in which those foreign patents were prosecuted have the dominant interest in how those communications relating to the foreign prosecutions are treated. And so when analyzing the application of the privilege to those foreign patent applications, they actually look to the law of each country that has a foreign counterpart pending. And so there's one case, the In Re Rivastigmine case, where the judge was actually asked to review the privilege laws of 37 different countries. And so a lot of the cases end up as kind of a nightmare for U.S. litigators, because you're having, at the inception of the case, it's very uncertain, very unpredictable how the privilege analysis is going to flow in all of the various jurisdictions. And so, you can be comfortable that your U.S. communications with patent agents and attorneys are going to be privileged, but you really don't know where you stand in many other countries. And so there is a great deal of uncertainty at the inception of these patent litigations with foreign counterparts. particular difficulties arise where there's many countries that don't really have civil discovery, and so the U.S. courts have really struggled in trying to apply the laws. Like take Korea, for example. There's some cases that try to apply U.S. style attorney-client privilege to patent prosecutions in Korea, but being a civil law country without extensive pretrial discovery, they don't have the need for a statutory attorney-client privilege. Those categories of documents just simply aren't discoverable, so there doesn't need to be there's no need to carve out attorney-client documents from the overall scope of discovery. And so the courts have really tried to shoehorn different countries' laws into the kind of a more consistent approach into how they approach the privilege. There's been several examples of cases that there's been pretty extensive analysis. One country where there's been a lot of analysis on is Japan. There's a lot of U.S. patents that are litigated that have parallel patents that have been filed in Japan. And so in Japan, there is a distinction between benrishi, who are the equivalent of U.S. patent agents, roughly. They have a few more responsibilities and rights than U.S. patent agents, and then bengoshi, who are the equivalent of U.S. patent attorneys. And the courts have pretty universally held since 1998, when Japan expanded its civil discovery to be more like the U.S., that there is a benrishi client privilege, and so they apply a wider scope of the attorney-client privilege in Japan, in that they apply it to patent agents as well. Similarly, in Germany, England, and the Netherlands, courts have found that there are similar patent agent client privileges, again, broader than in the U.S. And then conversely in Canada and then also in France, they have found that there are no attorney-client privileges to the equivalent of a patent agent in those countries, so they've taken a narrow review in those countries. One case that really illustrates the difficulties of being involved in a complex patent litigation that does have these international privilege issues, and it is the Ravastigmine case that I mentioned a moment ago. As I said, there were 37 different countries. It's a very lengthy decision. It has some analysis under each one of them, but I'm glad I was not the trial litigator in that case. They had to arrange for detailed analysis of the laws of the 37 countries, and they had to get declarations from attorneys who practiced in many of those countries so that they could present to the court a reasoned analysis of what the privilege laws in those countries were, and then establish that it was broad enough to encompass the particular communications and documents that they wanted to withhold. And so the attorneys in that case had to get declarations from attorneys in Brazil, the Czech Republic, Greece, Hong Kong, Luxembourg, New Zealand, Pakistan, the Philippines, Romania, Slovakia, the Republic of Trinidad and Tobago, and the United Kingdom, present those all to the court, and then the court had to wrestle with what the privilege laws were under those countries. And so from a litigation standpoint, it is just adds an incredible level of complexity to asserting the privilege in U.S. patent litigation. And so that's a brief overview of that law. Go to John.
Why is yours not?
If you go under view, go normal.
Yeah, hang on, it's not coming up. Which one?
Can we just about close this window here? Oops. Oh, this is yours. Oh, yeah.
It says it's
there
yours.
It is.
Okay,
Perfect.
there we go.
All right. Michelle is right. When we get together for a wedding or a funeral, my family, someone will say, last week I found the most interesting writ, and the audience will split in half. I'll leave it to you to decide where the interesting people go. It's always a pleasure for me to speak about geography. I was one of the few, the proud, the geography majors. So, of course, that's why I ended up at a patent law firm. Anyone know how the University North Carolina tells the entering students why they should take geography. They show the average income of the graduates from the geography department at UNC Chapel Hill in an attempt to show it's by far the highest of any major. Anyone know why? Michael Jordan, geography major. He's one of us. He's one of ours. All right. I want to talk about different geography issues, so it's going to be a little bit of a hodgepodge. I'm going to touch on several topics. I'm not going to do what you often see in an ethics talk, which is sort of sky is falling, be really afraid. My basic takeaway point is have a theory of why you can do what you're doing. It's not too hard to get a theory. So make sure you have a theory and you think about it. Make sure you mind your advertising, your website, your cards, your correspondence. And I'll tell you who's most concerned about that stuff. It may not be the licensing agent. And then third, I will touch on secondment, which is visits, inbound or outbound, either from people working for the client or from other law firms. And secondments is one. I won't say the sky is falling, but you should take a little bit more care with secondments and visits. First, let's deal with federal licensing. We all know from Sperry v. Florida, if the PTO says that you can do an act, then no state board on unauthorized practice of law says you can't, because federal law is the supreme law of the land. And so if you are a patent agent or you're a lawyer, as long as you get that reg number, as long as you get that reg number, you get to play the trump card of supremacy law. But and it's very clear, anything within the PTO that a patent agent or patent lawyer can do, the state can't complain that you're doing it. But how wide or how narrow is that? In other words, what's at the outer rim of that? What's at the edge? I hear people who have their reg number and are licensed in a state where they have no license tell me, well, I've got a PTO reg number, I can do anything. And I say, well, you can do almost anything, certainly anything the PTO says, but what's that outer limit where I think you have to take a little bit more care? And we wish we had a lot more case law on this. And so I think we have to construe it with reasonable principles, but you also have to construe it in light of the danger. So I want to return to why might this matter? I don't want to throw this out just as a theoretical level. Where could the attack come from? I often say that quite often legal ethics is simply a brick they throw at you. In other words, one reason to comply with ethics, besides that it's the right thing and we're all ethical, is to know how other people can use it against it and keep that in mind. Well, the most recent skirmish we've had on a federal regulatory definition of the practice of law came in SEC practice, when the SEC came in and wanted to regulate the securities lawyers. And representing corporations in transactional work, of course, has always been a core aspect of state law practice. And so we really had teed up a federal-state issue where the states, through their Supreme Courts, actually, and in some states like California through the legislature as well, had regulated this area, and here come the feds. And the phrase in that setting was appearing and practicing before the SEC. And first, the SEC said, well, appearing and practicing before the SEC is giving any advice which might affect any filing with the SEC. And if you work with lawyers who represent publicly held companies, although you don't consider yourself a corporate lawyer, you know when they're putting the 10Q together, the 10K and their disclosures, and they may ask you a question. So people wonder, well, wait a minute, if I answer a question to the corporate lawyers knowing that they're thinking about the SEC filings, did I just appear and practice before the SEC? And the initial regs from the SEC said yes. And then they trimmed it back a little bit. But the larger point is, I think the federal agency will want to construe it broadly, but the state will probably want to construe it more narrowly. So it may matter who's doing the construing and how this comes up, and it may come up subsequently in a lawsuit against the lawyers. If, for example, you're trying to collect fees, or you're being attacked by the other lawyers for some reason. So I'm curious, a show of hands, how many people would say, if you've got a PTO reg number, filing a patent application is clearly authorized federal practice of law and you don't need a state license? How many people would say that? How many people would say meeting with the client to discuss building the portfolio? So you're not filing an app, you're not writing out an app, You're aware of what the market is out there, and you're talking to the client. You might want to build out your portfolio in the following areas of technology. How many people would say that's appearing and practicing before the PTO under my PTO reg number? How many people say I'm not sure? I'm not sure if that's okay. Fair enough. We're starting to get it. I'm not sure. Suppose the client comes to you and says, "Look, I need to start thinking ahead of time about how we're going to enforce this stuff. Send out some. You might be interested in this patent letters, offers to license, and then we have to be thinking about phase 2, which is potential litigation. I won't have you do the litigation, but certainly you understand my portfolio. Help me think about the phasing of these patents you procured for me in getting licenses from various people. Bear in mind, we're going to let the litigator, some other litigator, litigate." How many people say that kind of a conversation strikes you as within your PTO reg number? I saw a couple of hands wavering. How many people say fairly clearly not to me? All right, now how many people would bet all the money you own that there's at least one patent lawyer in the country operating under a PTO license who does start to veer into those conversations? So, lawyer or agent. I mean, a few do, right? In other words, my big point is that people have their reg number and start to veer into areas where we are less sure it's covered by the federal, by your federal ticket. So, why does this matter? Well, it rarely comes up in a PTO discipline matter. And to date, the only times I've seen it come up in a state matter is when a patent agent explains what they've been up to for the last several years and is trying to get a state license, say in California, and someone fairly uninformed within the California State Bar says, "Oh my gosh, I look at your resume, it looks to me like you've been practicing law for 5 to 6 years." And then you have to walk this person through the fact that this patent agent has a reg number. But if you go to collect fees, and it's a big number, the client, the stats show about 3/4 of the time when you sue to collect fees or initiate arbitration, there will be offensive claims back against you, whether or not you did anything wrong. So you will have lawyers, presumably a litigator, picking over the bones of everything you did for them, looking for any weakness. And unauthorized practice of law in California is a grounds to deny any legal fees whatsoever. We have the Beerbrower case, kind of a famous case. So that's one of the grounds they'll be poking around in the federal licensing area. I would say the takeaway is, if you think legitimately this isn't necessarily filing an app, keep tying your advice and your discussions to how closely this ties to the applications you have filed or may be filing, because that's the highest ground. And to the extent that you believe anything on the outer perimeters ought to be included under PTO practice, I would tie it explicitly when I talk to the client, and certainly, when I'm writing correspondence or opinions, that, this bears on the applications that are pending and the applications we are thinking of filing. I think that's not illegitimate. I think that is, in fact, the link between the two, but I think having that written record that it is tied to that and affects that and in some sense derivative of that gives you your highest ground if you are one of those people without your state license practicing in this gray area at the margin. So those were my comments on federal licensing. I'm going to move on, and we are going to take questions at the end. I want to talk about different types of residence issues. Obviously, we've just covered the situation where you do have a PTO number. How about you have, let's say, a license to practice law in New York. You end up moving internally within a law firm, but you figure that's okay. You've got your PTO license, but you do support litigations. And now you want to get involved. You might even want to write meet and confer correspondence. You might even want to show up at a deposition, but you don't have a state license for the state in which you are residenced. What is your status? Well, quite often in these federal cases, you pro hoc vice into the district court where those cases are pending. And once again, I think we have solid case law that a federal court, United States District Court order, pro hoc viceing you in on the basis of your Minnesota or New Jersey license, that's federal law, supreme law of the land. You can do what that court says you can do. I don't think there's any problem with that. The difficulty, though, is when you're in that same quasi-litigating support status and you're involved in a case where you haven't been pro hoc viceed in. What is your status? And I know some people say, in that case, I don't go to depots, I don't write the meet and confer, I don't get on the phone and do the meet and confer, I do support in substantive ways. Geez, am I any different from a law clerk? And I think if you're careful not to make the general appearance and not to engage in the direct advocacy with the other side, again, I think this is fairly low-risk stuff. If, though, you want to support a litigation in your state where you don't have the license, most states are not going to let you get a pro hoc into that situation, and you're really going to have to be a lot more careful and not give the other side an angle to shoot at you. Because the danger in this setting, is your opponents will try and make hay of this, or if there's attorney's fees at the end, they'll be picking over it and say, we don't, even though we lost, we don't have to pay for the unauthorized practice of law. Again, it won't be one of these generic complaints that arises genuinely. It'll be someone who has a monetary incentive to go after your licensing situation. So in those situations, think hard. Why could I show up at a depot? Why could I do a meet and confer? Quite possibly you can't, and you're going to see if you can find someone else in your office to handle that piece. I do want to mention briefly intrastate work for a corporate employer. Is there anyone here who is an employee lawyer and their only client in all the world is their corporate employer? Okay, so I'm in that category too. In California, they had this problem of sneaking around in the margins of the law where it was happening, people were being transferred, you go out there for 2 months. California and most states have now adopted a process I assume you all know about. If you don't have your California license, you can go to the California State Bar and in essence say, I'm an employee lawyer, I have only one client, it's the corporation, they know my status, and I agree to be disciplined in your system if I were to do anything while here that would be unethical, and you can essentially register in through that process. All right. Secondment. How many people have, it was the East Coast law firms that kept hitting me with this. I used to thought of it as lawyers on loan, but there's this old-fashioned term, secondment. How many people have been fairly close to a secondment situation in an IP setting? Okay, so a few. Secondments obviously can be inbound, outbound, they can be lawyer or client. What do I mean? So the foreign client might say, particularly in a part of the world where they don't have as many lawyers and they keep licensing tight, we would like so-and-so who manages our patent portfolio to spend 3 months at your firm learning about the American patent system. And you think this is fantastic. What a client binder. What a great way to build a deep relationship with the people who matter there. But, bear in mind, some of these people are doing stuff overseas that looks suspiciously like the practice of law. So that would be an inbound client secondment. But then the foreign associate, how many people here work with foreign associate law firms, whatever you call them, other law firms in other countries where you very often they'll want to send a junior lawyer over or something to train a little bit. These are a lot more difficult for me. My advice is from a risk management side, if I can prevent them, I'd like to prevent them. Some people say it's so important, we have to do it. Okay, so this person's going to come over. If it's not a lawyer and it's from the client, they can't be working on other clients' files. And I've talked to a lot of bright lawyers in my position, and there's just no way. You have client confidences to everyone else. So they're really not a lawyer on loan. They can't be treated that way. So we've actually had offices that are physically outside our main offices, where we have an extra room in the building somewhere. And that's not fun for them. They want to be in the mix, but they can't have access to the online database system, and they can't be learning other clients' information. And that conversation about the practical realities of how that wall will play out sometimes doesn't make the sponsoring attorney within your firm happy, but that's the way it is. If it's a foreign associate coming over, sometimes you have more latitude because I think it's fairly easy with an exchange of letters to set it up that they certainly can help work on patent matters that their firm is jointly responsible for, is working on back and forth. And so they'll show up here, they'll work on that stuff. Now, are we facilitating the unauthorized practice of law within our law firm? I think if they're coming over with a foreign license and they're working on matters that their firm is working on jointly with us, I don't see it. I haven't heard of anyone being busted for that, but that's sort of the rundown of the risks on the secondment issue. Finally, public statements. This is one where people can be picky. The DC bar can be very picky. When you apply to waive into the DC bar, they say, give me every business card you've used in the last 5 years and correspondence. And they're paradoxically, they want you to come into the DC bar, they want to facilitate it, but they definitely want to slap your wrist if you've not had business cards and correspondence ahead of time that clearly disclaimed that you're not practicing. For example, if you show up in DC too early and spend a few weeks there and then start applying, they're going to slap your wrist on that. So I get in these discussion points all the time. On your website and business cards and correspondence, put it somewhere automatically on all of those things, where you have a license. If you are a tech specialist or a PhD working in a law firm, make sure it says none. Make sure it says bar admissions, none. And then use the word support or assist. They support or assist a such and such practice. And you will get pushback on that. But tell people, and this is true, no one else will see these disclaimers. They won't bother anyone. They won't bother the clients. They won't bother people. The only time they will have effect is when you do have the particularly picky state bar people pouring over it. It will matter very much to them, and if you do it correctly, you can have a complete defense on that stuff. So it's worth putting all those little disclaimers in, even though people don't want to hear that. All right, so that's my 10 minutes. Michelle?
So now it's time for my favorite game show, Stump the Panel. Any questions? Yeah.
In terms of outsourcing, one thing that used to bother me was that the U.S. has export regulations, and as far as export to X, Y, and Z countries, and it seems like patent technology is one of those areas that you're having outsourced. India was at one time, I think, one of the X, Y, and Z countries. How do you get around that?
Outbound restrictions on technology are very much at play if you're sending your patent work out, for example, to India. And so you have to be very conscious as to what kinds of patents are being sent out there. So it is definitely another hurdle you have to jump through and think about. There's a guy out of Holland and Hart named John Tredenick who runs an outsourcing service. And if you really want to explore outsourcing in some depth, talk to this guy. He knows every issue as it teed up. He may convince you, he may not, but he'll point you to the ethics opinion in the issue, including this one. My 2 cents view is when they want you to outsource the patent and you look it over, I translate it this way. Of course, I'm into risk management. I translate it this way. What I like to do is get really inexpensive legal services, and your value add will be your malpractice insurance policy. Okay, so for which I will pay you almost nothing, but you'll have a huge value add. Sound like a good idea to you? I mean, that's how I view the whole process. I will say other jurisdictions allow you to limit liability reasonably. The ABA model rules say you can. No state has adopted the rule by which an American lawyer can prospectively limit liability. This, to me, is a classic case where we should adopt the ABA's formal approach and say, if the client says outsource it and you just review it, the lawyer ought to be able to say, fine, but my liability is capped at 20x the legal fees I pay you because you're specifically not having me do the guts of it. We're not there yet, but if outsourcing continues, as patent lawyers, I think we have to push for that. Even 20x the legal fees limitation would keep your insurance down low on this particular issue.
Yeah, over here.
Waiver by use of the attorney-client waiver of the privilege as it relates to patent litigation expense and trial counts.
Oh, the EchoStar case?
What?
That's the EchoStar case?
It's actually raising it. And they're also going to extend the question as it relates to the problem. Seeing as they've invited the public to weigh in on damages, and that'll give you the first chance to finish.
Well, that was the question that was left open by the In re EchoStar case, I think last year before the Federal Circuit. There had been the issue was what is the breadth of the waiver of the attorney-client privilege when an accused infringer offers an opinion of counsel as a defense to willful infringement. And there had been a lot of back and forth in the district courts as to whether the waiver of privilege applied to the opinion counsel, whether it applied to all the attorneys in that opinion counsel's firm, whether it applied to even trial counsel. And the EchoStar decision, the facts were a little bit narrower than a lot of the cases. There was an external opinion counsel, but the language of the In Re EchoStar decision was extremely broad, and a lot of people read it to mean that it was a subject matter waiver on the terms of the opinion letter with all counsel, and that it did extend to trial counsel. And I know in that case they had asked for en banc review, and they denied it in that case. And so that's good news that the court's going to look at that again. As a trial counsel, I would say certainly it should not apply to trial counsel. Only opinion counsel.
I was hoping that was your answer.
Can I follow up on that? One of the places where attorney-client privilege in patent prosecution comes into litigation is when there's a charge of inequitable conduct, or as it used to be called, fraud on the patent office. And as to attorney-client privilege, there's a crime-fraud exception that allows you to discover certain information if there's fraud. Has there been any cases that you're familiar with that have dealt with that domestically or internationally?
I think domestically, the basic standard is you have to show a prima facie case of inequitable conduct before you can pierce the privilege. If you just allege inequitable conduct with no meat in a complaint, you don't pierce the privilege. I'm not aware of any cases that have specifically looked at that internationally. I think it would, in view of the cases I discussed earlier, I think it probably would go to the laws of the foreign country to see what the crime fraud exception was there. You'll say it was an English patent, they're alleging inequitable conduct in the prosecution of an English patent. They would have to look to what the law of England is to see what the crime fraud exception there is and whether it reached the communications at issue.
And the prima facie showing is the mechanism the federal courts use for crime fraud in other settings. Very often in drug cases where there's lawyers involved, or financial fraud, Ponzi scheme cases, the prima facie showing. Much harder to do in state court, but obviously all your patent litigation will be in federal court.
I think one of the others that's developing in that is the electronic discovery area, where people are now saying, okay, counsel advised you about your preservation duty and you didn't meet it, so there was a crime fraud. And now we're entitled to know about the communications about exactly the scope of what the attorney told you to preserve. And there's some fairly, I think, frightening case law out there for in-house counsel who may be advising clients on that, where they're going to try to pierce the privilege through crime fraud exception about the preservation duty. So they're not patent cases yet, but I think we might see that start to bleed in as well. Yeah.
Practicing law question. If I write an amicus brief in the Supreme Court, and I'm a law professor, and I'm the amicus and the author of the brief, practicing law?
I think you're representing yourself.
Sorry.
The question is if a law professor writes an amicus and the professor is the amicus, is there a problem? Now you're going to make it harder for them. The first answer is you're allowed to represent yourself, obviously. So you represent yourself as the amicus, but you're writing it for 20 different. Can you find?
So right. So the question that's binding now is I happen to be a mediator on the Federal Circuit's mediation panel. They have a rule that says mediators can't practice law. Over the last year or so, I've been filing a number of amicus briefs in the Federal Circuit. In the Supreme Court. New interpretation of the Federal Circuit's rule comes down quite recently. You sign an amicus brief in which you are the amicus and the author, and a buddy signs on as another amicus. You're now practicing law.
Is that what the opinion said?
So it's an informal communication from the court to essentially block any of its mediators from writing amicus briefs in the Supreme Court.
No, but you can, if you don't sign the brief as author, and you are an amicus, are they still saying you're practicing law?
I don't think they would.
That would be crazy.
If you held to the brief, then you would be.
Well, what you should do is you should find someone with a legal ticket, and you can edit it away because you're working under the supervision. I mean, the magic words are under supervision of the lawyer. Anyone who's done solo practice knows this, the receptionist may, in fact, interview clients, write up the interrogatories, do all sorts of stuff. As long as it's under the supervision of an attorney, you're swept in. So I would edit away, but you may no longer be able to put yourself down as the author.
Right. So my understanding is that a number of the regional circuits that have rules like this expressly permit it rather than prohibit it. Do not all matched up.
And I would urge them to rethink that aspect of their decision. Oh, by the way, I'll do what I tell everyone to do. But of course, this is not legal advice, and you are not my client.
A nice disclaimer right there. Good example. Other questions? Yeah.
Now, John, you did a great job of addressing people with registration numbers changing residence.
But what do I leave out? I can tell the shoe's about to drop, right?
Yeah, well, no, but exactly. Very common practice these days has to do with, or problem it seems to be with multi-state practice. You had a Chicago firm representing a California client that's been sued in a Texas district court. The California client has multiple offices all over the place, Washington State, California, and so on. Chicago firm sends attorneys all over the place doing discovery, taking depositions. In other words, conducting the practice of law all over the United States in jurisdictions where nobody is admitted. This is a common practice. What kind of advice would you give?
Well, if let's say it's in the Eastern District of Texas, but these lawyers have made an appearance there. And I think because you showed up and made a general appearance in that federal court, all the aspects of the litigation in the United States, interviewing a witness in different states, sitting in Chicago, writing a brief, I don't have any problem with that. The problem we had in California, nor do I think anyone should have a problem with that. The problem we had in the Bierbauer case was a California corporation reached out to New York lawyers. None of them had a California license. And because it was an arbitration, there was no opportunity to get pro hoc into the dispute in California. They showed up and did the arbitration itself in California. And then again, like I said, why does this matter? The client walked out on the fees. The lawyer sued for the fees. The client had new lawyers who said, unauthorized practice of law. So make that general appearance and append things legitimately to them. However, if it's an arbitration, in Texas and none of the Chicago lawyers have a Texas license, then you're probably going to want to talk to your local ethics guru as to what is our theory of why we're showing up there.
Yeah.
Question, this is different than patent licensure, but for export control licensures, let's say we're in-house counsel and we have export control people that work with us. Do you have any advice on ways to make sure that we are maintaining privilege that we need when there's interplay discussions between export control people and
the export control people are not lawyers.
Not lawyers.
Okay, there's two ways to go with people who are not lawyers inside a corporation. One is, if you can, to put them under the supervision of the lawyer all the time. Now that may hold up, it may not, factually. And for example, some large corporations have contract specialists, licensed specialists. They know how to read a contract better than anyone. In fact, they end up negotiating the things. I used to do a lot of anti-gray marketing crackdowns for companies in the Valley. I didn't know. The contract specialists are not lawyers. So you can either put them under general counsel, so you have the org chart with the line of command and supervision and control, or if that can't work out politically, have them have the discipline to recognize there are some things. There's dotted line. They at least have a dotted line to you on legal issues, and on those they're using the legend. They're using the attorney-client privilege materials. So to me, it's an all or sometimes. The answer will matter. You do have to sit down and work with them. If it is a sometimes they have two signature blocks, so they put the legending in as appropriate. That one takes a little bit more effort, but the fact of the matter is that may turn out to be a more accurate representation. If you put them under you for all purposes and the testimony comes out, they talk to you once every 3 months, the court might just swipe all of your attempts away to keep it privileged. So it's all or sometimes, and it takes some education.
Anything else for our panel? I think they acquitted themselves quite well with my game show stuff panels. Thank you.